Thank you, Sheriff. Y'all may be seated. The jury, the audio system is not working right now, so listen carefully. I told the witness and the lawyers to talk as loud as they can. Mr. Lane, you have this witness on cross-examination, and sir, I'll remind you, you're still under the oath that I gave to you previously. Mr. Lane, you may proceed when ready.
Thank you, sir. Dr. Hayden, did you get some water you were looking for?
Yes, I did. Okay. And my mic is working.
Well,
for that, go ahead.
Got a whole wires. We were basically talking, you and I were, about what the procedures that were in place as this incident unfolded. We talked about the officers being there and they were being polite and courteous and trying to be forceful enough to get kids to go home. You agree with me that they showed no disrespect. They were pleasant and were doing good police work, good community police work.
I would agree with that.
You agree with me that you heard on the video or on the body cams, you heard what we all have agreed, and you agreed, was 12 shots.
I don't know if it was 12 shots, but I remember multiple shots. Yes.
And you agreed with me that you thought that, in your mind, that most likely that would have been a semi-automatic weapon.
In all likelihood, yes.
In your investigation, when you were doing this, did you find that part of some of the eyewitness testimony that they said they saw more than one shooter shooting?
I'm not sure what Jeremy Seaton and Eric Knight saw, but they did say they saw a shooter shoot into the air. But I'm not sure if they said more than one.
You agree with me that Officer Gross moved immediately out in the street and began to stop cars.
He was moving out into the street and trying to stop one car.
Well, he did stop one car. He told them to stop that car, and they stopped. You saw that on the video, didn't you?
Which vehicle were you talking about?
The one that he said stop, and it stopped, not the one Vidal was driving.
I don't know. I'd have to look at that video to tell you.
That didn't register with you that as he was moving up that street, you saw his flashlight. He was doing what I assume good police officers do. He's looking everywhere. It's dark out there. And he said to one car, stop that car. And it stopped right there in front of him, right beside him. You don't remember seeing that?
I don't remember seeing that.
Okay. Well, you would agree with me that that meant that at least at that point, Gross's mind wasn't a threat to him or Oliver, either one.
What I heard Gross saying was stop the car, which was the victim car that he was talking about. I didn't see any other, so I don't know exactly what was going through his mind.
So that wasn't something you factored in to your opinion then?
That he was telling the car to stop?
Well, he had drivers complying with his commands out there.
I didn't notice a driver complying with his command. I don't know if that driver was complying with the command, and I don't remember seeing it, so I can't even really speak to it.
Well, assume for a moment that he did tell a car to stop and it stopped. As a police officer under those critical situations, not knowing what in the world is going on, would you think that that officer thought that this vehicle is complying with my commands?
If Officer Gross was looking at that vehicle and that vehicle knew he was looking at him and said to stop, then yeah, that vehicle would be complying with his commands, but I don't know if that happened or not.
Well, everybody can look and see. Okay?
Okay.
Now, as he was moving up the street, in the middle of the street with no protection, you saw him doing what I would refer to as a sweep. You saw his flashlight going back and forth.
It appeared to be, yes.
Well, is that good police work?
Yes, it is.
Why is that?
He's trying to get as much information as he can, trying to see what's going on.
See if he can see a shooter, see if he might see bodies, anything he can put in that computer of a brain to figure out what's going on, right?
That's correct. I would assume that's what he wants to do.
Then his backup officer heads to his patrol vehicle and gets out a patrol rifle, and you think that that was good police work?
It was adequate. I don't see a problem with it.
Okay. And you know that that Oliver was properly trained on that particular weapon?
I don't know if he was or not.
Well, you didn't check?
No, I did not check what his shooting records were, but I know he's a good shot because of his
I'm
shot
talking
pattern.
about what's required for a police officer. You have to be qualified by a range master to shoot at a particular weapon, an AR-15 or this particular carbine.
Yes, and he was qualified to do that, but I don't know what his training was to get to that point.
Because you never looked at any of his training records.
I didn't look at his training record.
So he moves up. Oliver gets the weapon. He chambers the round. You think that's the proper thing for him to do?
That's fine for him to do, yes.
And why is that? Why, under your theory, why wouldn't you think you should wait till he gets up there and analyzes everything and then chamber a round?
What you're trying to do is you're trying to do things in a sequence that you understand. When he pulls that weapon out within his own department, can he chamber a round? And at that time would be the best time to chamber a round, but still carrying that weapon in a safe way. Not pointing it at anybody, just pointing it in a safe way, not finger on the trigger. So I believe what he was doing was proper police action.
Then he is the backup officer. You're aware that Gross and Oliver had been partners for some 4 years.
When you say partners, I look at partners as guys working together constantly all the time.
Well, did they tell you that they were bike patrol officers in the summer, he and Gross?
And did they pedal next to each other? I don't know.
Yeah.
I don't
Community, and would you agree with me, that's pretty good community policing. Get out and meet everybody, stop your bike and talk to them. Small
Yes,
community.
it's community policing, yes.
Yeah, 20 city, a town of 25,000, that'd be good police work, wouldn't it?
I can't speak for Oak Springs, but it sounds like good police work.
You can't speak for Texas police officers either, can you?
Not within the regulations that you're asking me to speak to.
So, did they tell you that, or were you aware that Gross was also a combat veteran out of Iraq?
Yes, I am.
So, and you being, and certainly a combat veteran, and what can we say other than thank you, but two combat veterans working out there together, do you think that they gave Oliver and Gross more comfort just because they knew each other, they worked together, they knew their history, their training, things of the way? Does that make a difference to you?
Being two combat veterans out there, I would say they have a camaraderie, an understanding of what was done in combat.
The brother.
It's a brotherhood, yes it is.
Yeah. Good cops have partners and they're their brothers. And good soldiers like you have certain soldiers that, and all of the men that were under your command were your brothers, correct?
Yes, they were.
And your job as a commander in a combat zone is to make sure your troops got home,
Yes.
correct? That's the most important thing to you, wasn't it?
It was the most important thing to me, not the most important thing to the military. The mission was the most important
Well, I
thing there.
appreciate that. Because there were so many people that were, well, we don't want to go there.
Right, you don't want to do that.
No. So you understand that Gross and Oliver had a particular brotherhood, or a real close relationship.
I don't know if they did or not. I know that being combat veterans, I would assume that they might have.
And would you agree with me that if one veteran who's used to working with another veteran in a policing environment, that they kind of learn to watch each other and the way they react and the things that they're doing as a cue for what they're supposed to do?
That would probably be most likely would be one of the things that they would pick up, yes.
And you heard on those body cams that as Gross came up that street and Oliver was coming up behind him, Oliver was walking, but then when his voice started going up higher and higher, stop that car, screaming out the license plate numbers. You agree with me that you heard Gross's voice elevate completely?
I I did hear his voice go up, yes.
And he used pretty salty language too.
Yes.
And I've always been convinced that it's part of a training program, and all police officers go through a training program learning to use salty language when they get in a high-risk situation.
It seems like a lot of police officers do use that language.
Well,
yes.
it always comes out when they're in a high-risk situation, doesn't it?
Yes, it does.
In fact, it may be used more and more in a real high-risk situation, correct?
In high-risk situations, it's used a lot.
So Oliver knows Gross. He hears Gross, his voice raising higher and higher and higher. Would you agree with me that, looking at that tape, that's when Oliver began to run?
That's just about the time he began to run, yes.
Now, would you agree with me that if he's running because he hears his partner hollering at a particular vehicle to stop, and the vehicle is not complying, that Oliver, at least at that point, should be highly anticipating something may in fact be happening?
I do believe that Officer Oliver, at that point in time, when Gross's voice did go up, did get a heightened anxiety, and that's when he began to run. And as he ran, he focused on what he thought he had to do at that time, and what I believe it is stop the car. And that's what he did.
And in fact, he has a general order that allows him to do that if he had a reasonable belief that his partner was going to be run over.
Not really. The general orders is you have to stay within the federal and state laws. And, shooting somebody because you think there's a problem is not justified under federal or state laws.
Well, I don't see anything in this general order that says something about thinking, and I don't think I ever read anything in Graham versus Connor that said anything about thinking. I think what the law said is you have not told this jury that came out of Graham versus Connor was that it's a reasonable belief.
A reasonable suspicion, belief that there is a threat. Is there a reasonable belief that there's a threat at that point in time? And that's what I brought up before. Would the Officer Oliver, as he's approaching, and he sees that Officer Gross is walking up to the vehicle, and he's not anywhere near that vehicle, would he have a reasonable belief as he's getting close, and within that fraction of a second, would he believe that his partner is in danger? And what I'm saying, and I'm still saying, is that there's no way that he could have looked to see if there was a danger and he didn't have reasonable suspicion. You have to have belief that that is occurring. And there's no way that I can see that he could have turned to see that happen and get back on target and shoot.
But you and I agree, as you told us before, that you actually assess these things differently than other professionals.
Well, everybody has a right to be wrong. It wasn't me.
And you've never been wrong, have you?
Well, I've been wrong. Just ask my wife, and she'll tell you that.
I'm not talking about your wife. I'm talking about in assessing a reasonable threat.
And looking at this, I don't believe I'm wrong. I believe that there's enough data here to say that what actually happened was Officer Oliver did not have a reasonable belief to believe that he could use deadly force, and he should not have used deadly force. Round 1 or 5 should never have been fired because there was no threat to anybody. Nobody's life was in danger, and I don't see anything here that says that anybody's life was in danger except what Officer Oliver did.
And you were making that assessment after having the benefit of cool reflection and reading all the depositions and going over it. I bet you watched the tapes more than once, didn't you?
Yes, I did.
And you went through it all with the district attorney's office over here, didn't you?
Yes, I did.
And they told you the elements of the offense, didn't they?
Yes, I did.
And after all of that, and you've been hired as an expert, then you formed an opinion, correct?
I formed that opinion after looking at all the evidence that I could see from the grand jury testimony and from the video analysis that Grand Frederick did, and from everything that I read. The information that I saw all led to what I believe a reasonable officer would say at this point in time, that what Officer Oliver did, he had no justification for shooting. He should have seen what was going on, and he should have been able to see that there was no threat to his partner, Officer Gross, which there never was a threat to Officer Gross.
But of course, you agree with me that the courts have been very quick to remind you and all experts and everyone else that you have to look at it from the standpoint of the individual that was involved.
Yes, you do.
And you have no way of knowing what he saw or what he thought at that point, do you?
No, I do have reason to believe what he saw at that point, because I believe it's based on science. It's based on what we talked about, Dr. Lewinsky has already said, is that when I'm looking at something, I'm looking straight ahead, I can focus on that one finger. This finger's out of blur. It's in my peripheral. I cannot make a decision based on what I don't see. I have to see the threat. I have to see what's actually happening for me to make a decision, a logical, good decision, sound decision, that I need to use deadly force. There is no way he could look over where Officer Gross is, then get back on target and fire.
Where does it say in Graham versus Connor or in this general order that we're talking about logical and good decision? It says a reasonable belief.
And I would, if we're going to go back to those words, I'd say a reasonable belief. Does he have a reasonable belief? I don't believe he could have had a reasonable belief at that time.
But he reasonably believes that a person is immediately threatening the officer or another person. That would be Gross.
Your Honor, I don't object to this as argumentative.
No, I'm reading right out of the journal orders.
That's exhibit number what, 20?
I'm marking my own out. No, this is the wrong one. It's the journal orders.
20, Judge.
Go ahead.
I just want to make sure I understand, because these are the general orders, and as a matter of fact, if do you have them up there in front of you?
No, I don't.
Well,
Oh, wait a minute, do I might have, yes.
on the first page, does it say these orders are effective? Look on the first page, the cover sheet.
The effective 2/24/12.
But doesn't it say also that it was amended on another day?
Amended 2/7/17.
So, in February of the year of this shooting, those orders had been amended, and that's the orders Roy
Yes.
Oliver was obligated to follow, or at least had guidance from his department, correct?
Guidance from his department, yes.
Okay, and it says that, however, if an officer reasonably believes that a person is immediately threatening the officer or another person with deadly force, do you agree with me that a motor vehicle can be a deadly weapon?
The automobile can be used as a deadly weapon, that's correct.
Then he's authorized with deadly force against the driver of the vehicle. Against the driver of the vehicle.
Which paragraph are you reading from right
Well, I
here?
read from the one that you read from. It's
Okay.
number 3.
That was which one?
Number 3 on page 4 of 8.
Okay. So you're talking about the objective reasonable? Is that what you're talking about?
Well, it says deadly force restrictions, and it's number 3.
I have definitions: the deadly force, the non-deadly force, and objective reasonable. That's what this one is.
Do you have general orders there?
These are the general orders,
Can
yes.
you look on page 4?
Page 4, yes.
You see under deadly force restrictions,
Yes, I do.
do you see paragraph number 3?
Yes, I do.
Do you remember reading that to the jury earlier?
Yes, I do.
Okay. Well, are you now taking issue with the general
I'm not
orders
taking
were?
issue. I was just trying to make sure that I was heading to the right one.
Well, I mean, but these orders were effective in 2012, but they were stamped as approved, and these are the orders as of 2017, February, right?
That's correct.
And you agree with me that a motor vehicle is a deadly weapon?
Motor vehicle can be a deadly weapon.
Well, yes, sir. Did you hear, you've been in the courtroom for the last day and a half, I guess, did you hear the tape being played in the conversation between one of the officers and Vidal where he said, they shot us and we were only backing up? You
Yes,
hear that?
I do remember hearing that.
That's not true, is it?
They were backing up, but not when the shots were fired.
Well, and he wasn't following the commands of an officer in a uniform And he said he saw the officer and he knew that he was hollering at him. You heard that too, didn't you?
I don't remember hearing exactly those words, but yes.
Well, you have no reason to believe that Vidal didn't know that was a police officer and he was giving him commands.
Yes.
And when he didn't follow those commands under those circumstances that night, that was a felony offense.
Just a felony offense, but not a deadly force.
I didn't
felony
ask you
offense.
that. I just asked you if it was a felony offense.
As far as I understand what the state law is, yes, it's a felony.
That's all I've got to ask. Thank you.
Very quickly, the paragraph that he just referred to that says you might be able to use deadly force against the driver of the vehicle, it starts off with, if an officer reasonably believes that a person is immediately threatening, correct?
That's correct.
Do you believe it was reasonable for the defendant to believe that Officer Gross was being immediately threatened?
Well, it goes back to my statements before, is that Officer Gross was in a position where he was approaching the vehicle. He was not in a position of being run over by the vehicle, and he was in a position of approaching that vehicle.
Okay, so that's...
And so, so he was not threatening at that time.
And you know that Officer Gross had combat experience, very similar to the defendant.
I don't know exactly what combat experience he had, but I know he was over there.
And you know they had the exact same police training in Bald Springs.
I know they had the same, yes.
And you know that Officer Gross didn't shoot his weapon, did he?
No, he did not.
And you're not making your opinions here based on 20/20 hindsight, are you?
No, I'm not.
MC5 carbine rifle firing 223 rounds, is that a firearm?
It's like what we had in Vietnam in M16.
Okay, deadly weapon?
It's a deadly weapon, yes.
Okay, and despite the cross-examination from Mr. Lane, you still think it was unreasonable to shoot those 5 rounds that ended up killing Jordan Edwards, is that right?
Yes, I do.
That's all I have, Your Honor.
There's always one last question. Dr. Hayden, I apologize. When you looked at this vehicle, would you agree with me that under those situations, that night, with all those stress factors, that the shots that were fired, though, were almost a straight line, and then the last one was down at the ground, or rocker, right?
Yes, that's what I understand.
Would you agree with me that somebody had pretty good control over the fire?
Oh, absolutely.
This wasn't some person out there thinking that they could shoot the neighborhood up.
No, as I said, he's a good shot.
That's it, Judge. Thank you.
As soon as he finally
From the state, yes, sir.
Yes, sir.
Thank you, sir. You may stand down. Excuse me for the service of this badge. You're free to remain in the courtroom or you can go home. Members of the jury, we are going to conclude for the day. So if you would please mind, hang on just a second. Hang on, hold on. Let me talk to you. If you would please mind my instructions, not to do any independent research, not to visit any locations, all the things you've been doing for this entire time, and I do appreciate that. We'll start tomorrow at 9. Does that sound all right?
Yes, sir.
Testimony at 9? Very good. So if you would follow the procedure that we started with on Thursday and Friday, be ready to be at 8 and come here. We'll start at 9. All actually, y'all may be seated. Before we recess for the day, is there anything else we need to do on the record?
No, sir. At some point in time, we're going to want to pick up 204B.
Okay, I'll let you know when I reach you.
Yes, sir.
Mr. Gill, is there anything we need to put on the record before we recess for the day?
Well, I was curious about the state's motion amendment about Graham versus Common. That's still in effect because they kind of blew right through in front of the jury over here.
I'm sorry, I don't recall that particular motion. What was the motion?
They made a motion to limit that neither side go into Graham versus Common. I don't know why they made the motion, but they did.
Whenever that was mentioned, I didn't hear any objections either. Is there anything else?
No, sir. So I guess is the motion limited still in effect? If we want to go into it at some point, you know, we'd be expected to approach the bench.
Well, I think that you can go into the issue now. Been talked about all afternoon. Thank you all very much. That concludes the hearing for today. We'll see you very soon.
That's 250.
It's right here.